Welcome to The Grant, the EU funding podcast. The Grant. My name is Niels Tudor Winter, and I'm the creator, editor, and host of The Grant. The Grant is an independent podcast initiative with the ambition to dig into all corners of the EU R&D funding system on topics of interest for the full EU R&D funding community. This episode is part of the implementation series with focus on project implementation. The episode is number 14 in the series. Intellectual property rights, or IP in EU funding language, is one of these elements in projects that can ignite the fiercest battles and hardcore conflicts. The rights to the project results are naturally where many of the partners' interests are vested. Hence, you want to do everything to avoid conflicts that can crash the project. IP lawyer Luis Rodríguez from RTDS Group in Austria took us through IP in the proposal phase, and now he will also take us through IP when the project has been funded. It became a long recording, so I have divided it into 2 episodes. In this first episode, we look at the Consortium Agreement, the transition from proposal to project, and conflict points, including some examples. Please enjoy. Welcome to The Grant, the EU funding podcast. Today I have the second 2 episodes on IP, and it's not long ago I released the first episode on IP in EU proposals and how to handle that. And now we're going to have the conversation about EU IP and EU projects. So, Louis, welcome back.
Thank you. Thank you very much for the invitation.
And chance has it that it's exactly this week that we the next, actually on this Monday, from when we're having this conversation, that I'm releasing the first episode. So it's that's out there. Before we do anything else, short introduction to yourself.
Yeah. So my name is Juan Luis Rodríguez. That's a long name, I know. I'm basically an IP lawyer. I work in RTDS Group. We're a consulting company in Austria, and we manage European projects. Particularly dedicated to managing intellectual property coming out of the projects, R&D projects, that are funded under the Horizon Europe program. And this is what I do.
Yeah, welcome. In first conversation was good and nice and in depth on how to deal with it in proposals. Short fly in on IP and projects. A few words.
Wow. Yeah. This. I think that the main issue is some people forget they don't understand what exactly or why intellectual property is so important in these projects. No? And I think, you can see in the grant agreement specific rules about intellectual property, and then in the consortium agreement, they also emphasize the need of talking about intellectual property. And it is basically because there's an expectation that out of all the intellectual effort coming out of these projects, there will be something, a result that is the output of intellectual effort. This is something very important nowadays with the artificial intelligence tools. It's an important definition. But in the case of intellectual effort from humans, let's put it that way, there might be something to monopolize, something that can be turned into money, and more innovation in the future. So there's where things can get complicated, because of course everybody likes the exclusivity to exploit something, to get this money out of the resources we get, or the advantage to develop something industrially. So that's where things can get very messy, especially in this collaborative framework.
Yeah, and this is in the projects, of course, that's where everything comes alive in the real life from describing it. Probably the patents and the IP is one of the most concrete things you have in a written proposal, because it's not something that can be bent, so to say. Yeah, so it's an anchor, so to say, in the real life, real hard legal life, so to say. So and this is what then becomes reality in the projects, right?
Hello, my name is Chiara Liguori. I've been listening to the podcast for half a year, but I invite you all to listen to it as well.
Okay, let's move into the first key block here. The starting point, Consortium Agreement.
Yeah. Well, indeed, the Consortium Agreement is, I would say, the Bible. Okay, well, I don't know if it's first the Constitution and then the Bible. What does it come first? I don't know. With the grant agreement, right? Because in the grant agreement you have a lot of rules, principles, also elaborated from the regulations on the Horizon Europe framework program, into more concrete actual legal provisions. But then when it comes to the consortium agreement, it is clearly mentioned in the grant agreement that the partners can otherwise agree, change or be a little bit more flexible towards how the relationship between the project partners will evolve. Of course, towards the objective that were already defined in the grant agreement. So, I would say that the consortium agreement is the most important document that not just lawyers have to deal with, but also the project partners. And the issue with the lawyers is very important, I would say, because it seems to me that most of the consortium where I've been working on, people leave the legal stuff to the lawyers, right? They initiate, I don't know, like this. The project starts. People start working on their task, implementing all the sharing a lot of information, providing each other materials, and so on. But if they don't understand what are the terms and conditions that they already define in the consortium agreement, their lawyers define in the consortium agreement, then there might be troubles, right? People perhaps might be confused regarding what would be the field of use of some technology, or if they have the rights to use something for commercial purposes, or if they are really allowed to disseminate, to promote, to write some publications about particular technology. So these are things that are really that tend to be clarified in the consortium agreement by the lawyers, but they also have to be reviewed and implemented by the researchers and other people involved in the consortium, right? So this one of the main things in the consortium agreement. So that's why you have definitions, specific definitions defined there, and you have these additional terms and conditions when it comes to background. I think in the previous episode we talked about the importance of background. In this case, now when we are doing the project implementation, we don't have results yet, no? At the beginning of the project. So what do we do when we're writing a consortium agreement that at the beginning of the project where we don't have any results? Can we define some results in a legal document. So it tends to be very difficult to predict all this expected results in the consortium agreement, which is just a document defining the collaboration, talking about something that we don't have yet. The only thing that we know for sure is about the background. So that's why you have a specific definition when it comes to accessing background technology that is required to implement the projects. You have normally in the consortium agreement a section about access rights for project implementation. They emphasize the principle for accessing these whatever is listed as background. And you have a specific template that is very important, and people tend to forget about it, which is the attachment 1 of the consortium agreement. There you have an entire table where you are required not just to list all this background technology or resources you will need during the project implementation, but also the conditions, right? Any restrictions that might be linked to this background, right? So there's something that people should be really careful about it. When it comes to, we were saying that in the previous episode that IP management is not just about protection, about patents. It's more about the management of who has the right to use and exploit and disseminate, and these particular terms and conditions that we have to define, somehow in this template in the consortium agreement for the background included. You have to be very precise. I think you can be very concise and define some of the rules, or conditions. Just to give you an example, I've seen projects where some people bring in the project a database that doesn't even belong to them. That was trusted to them. So there are some additional terms and conditions ruling this database. There might be even some licensing agreement, that forbids the use of the data for commercial purposes. So it means that probably I will not be able to use the data for post-project use if I need that information, and that should be clarified in the consortium agreement and communicated to all the project partners in a proper manner, in a transparent way. I think this helps to understand what would be the possibility towards exploitation of intellectual property, so on.
But that's, of course, this is looking at some things you can say often about technology development, but sometimes, of course, there are things you cannot. And you have lawyers that have spent their whole career in making putting down on paper how these things should be held, right? But it's just important. So if you're if it's one of these hardcore technology development projects, most likely there will be partners in there with lawyers or legal that will know how to do. But some might. So the issue, of course, is if you have SMEs where it's important, but they don't have this kind of heavy capacities. There, of course, is something as a coordinator to be aware of, to flag.
Yes, indeed. That's the problem. Also, we know that some technology transfer departments are also overwhelmed and similar like, to SMEs. And it can be, I know, tricky, it's a complex situation. That's why, I mean, in the projects that we managed, we run from the negotiation of the consortium agreement towards the very end, the clarification, the definition of the post-project exploitation plans, including the agreements around the use of intellectual property. The use of intellectual property also covers, for sure, the IP protection strategies and so on, and which is very important because people tend to forget that, there are impacts already. Several, in the grant agreement, you promise some impact, some ideas, what you will be able to achieve with the exploitation of this intellectual property. And and in order to achieve this impact, you might have to commit to maybe file a patent application, and perhaps there's another IP management issue, right, in the project implementation. If I need to file a patent application, that means that I will probably will be blocking the opportunities for some other people to disseminate or to write some publications on the same technology that is going to be covered in the patent. We have to balance during the project implementation. We have to balance which impact is better or expected. Is it the dissemination of the technology or the patent that will be later on exploited by a company and develop this product and so on? There's something that always needs to be negotiated. And in the consortium agreement, again, you have some specific rules for the prior notification procedure when it comes to dissemination. You have the confidentiality restrictions are very well elaborated in the section proposed by the DESCA model. I think they did a really good job on it. And these are things that sometimes it's even better not to, if you don't even negotiate the consortium agreement, they are already there.
And that's also maybe something to say to this, because there's not a formal consortium agreement format you have to follow. So here, if for this, it's not, the commission has nothing to do with this. So here is not the commission that comes and say you have to have this. This is something that is established in between the consortium itself to establish conflicts or whatever, resolution and something like this. Also procedures of the meetings, whatever. And here, what you mentioned there, yes, there has been then now developed some. Who mentioned the name again?
DESCA.
They develop sort of a to help consortia out there, because not everybody knows how, not all coordinators know how to deal with this. So now there's some sort of a format that you can guideline on how to do this.
Yes, indeed. And they also provide you with some recommendations and explain what would be the purpose of the clauses, that they, of course, this is a legal document, right? Mm-hmm. And if you don't comply with these provisions in this agreement, then it's better that you get the proper legal advice. I mean, the responsibilities here lies on each organization signing the consortium agreement, right? So it's important to notice that.
All right. Looking for partners for upcoming EU funding calls? The grant offers a partner scouting service if you're stuck finalizing your partner value chain. Go to thegrant.eu, check out the service, and send me a message. The grant, more than a podcast. Maybe we move on to the next block. IP in real life implementation. That's of course what I started mentioning. So we go from something that's been put on a piece of paper, suggesting how things should be, and now into developing things.
Yeah, indeed. Look, when it comes to knowing how agreements played out, you said here how agreements played out once the project is running. I have to say, again, people forget that there's a consortium agreement until there's a problem.
Yeah.
And then, oops, things are not exactly as I was expecting, or then let's check what is in the consortium agreement. And you have several things, right? I think the most common ones is when it comes to the dissemination, and when it's the most common, right? Because you have in collaborative research people and there is also their legitimate right? They want to disseminate the outputs of their research, and the problem is what happens when somebody says, no, I have already the priority to commercialize something, and I will need you to keep this information confidential. That's something that normally everybody tends to look into the consortium agreement. The other issue, perhaps, is when it comes to ownership of results. So I said before, there is not really. I know in the grant agreement you anticipate some result, right? But then it means it is a plan, no? But then during the project implementation, people may add additional components that were not foreseen in the grant agreement, or there is perhaps some additional changes when it comes to trying creating new formulations, or adding additional components that does not belong to the project partners, or that if they belong to the project partners, they were not originally described in the consortium agreement when it was signed at the beginning. So the consortium agreement again tends to provides you with the provisions to regulate this kind of situation. You can add additional background. You can redefine the rules, for granting access rights to background, or also to negotiate the terms and conditions for using results, as needed for post-project exploitation, or also for project implementation. So that is already well described. The problem is that perhaps it was not properly read during the project implementation, or people were not aware of what was mentioned there. So of course you need someone to clarify this process, no? Yep. And understanding what is the common basic principles on intellectual property management, IP law. If I tell you we're working together in developing a new technology, a new product, and then I just tell you my recommendation to you, Niels, is make it blue, just as a color,
Yep.
If this recommendation doesn't lead to a specific utility, doesn't add additional value, from the utility point of view, maybe there I would not be able to claim ownership. I'm just basically describing something about patent law.
Yep.
But if my recommendation to you is something that really enhance the utility, I'd say, okay, it's blue, but that just making this technology blue will solve several other problems, then I might be able to claim some ownership rights, or contribution, maybe not at the whole, but perhaps some sort of share of the ownership, and this is up to a negotiation between the joint owners in this case. So this is not directly mentioned in the consortium agreement, and you cannot do that entirely for each project result because it is a framework agreement.
Yeah.
You cannot just define specific terms and conditions for this particular result that we want to make it blue, or we cannot negotiate there some specific licensing agreement defining what will be the specific jurisdiction, the field of use, the duration of. That's not the purpose of the consortium agreement. So the consortium agreement gives you some guidelines on how to elaborate these other agreements, some basic principles, and people should understand that they have to negotiate these other agreements whenever they get to that point where they have to discuss who will be the owner, or what will be my rights to, when it comes to the use of this particular technology. So that's something that I will say we need to pay attention during the project implementation. If you don't do that, you're just going to chaos. Okay.
Yeah. And that's the thing, because now the next block, it's bridging perfectly into this, because that's the conflicts. Because that is, like everything runs smoothly. You don't even want to listen to this episode, right? Because that's the issue. Is with intellectual property rights and patents and so on in this context, is that when friction arise. So we talked about it in the proposal episode, that there are two things that can stop a proposal, or when it's really critical. That's the intellectual property, the IP discussion, and the budget. Now, when things are then carried out, it's also a point of conflict, because it's the most important thing for the partners, private partners, of course, patents, for the universities, licenses. So if at this point now we talked about the consortium agreement, the parts of that, what happens in the real life implementation, where the gaps from the description, and when Karen thinks out that there's might be a different of perception of how what was written is supposed to be understood. Now, let's have a look at the conflicts.
Yes.
Now, of course, naturally, this kind of you cannot share concrete, very concrete by name cases, but typical situations.
Yes. Like I also I made a question to the Mediation and Arbitration Center of the World Intellectual Property Organization. Some meetings I participated, and I asked them, do you know have you received some complaints, some cases coming from Horizon Europe consortium, people involved in this kind of research projects? And they told me, several.
Of course.
So you might end up in, hopefully, nobody wants to do that, but it can lead to these kind of situations where you might need the implementation, the execution of an arbitration clause, or end up in court, God forbid, So it can get very messy, especially when it comes, we're saying, issues on misappropriation of intellectual property. I think this is very dangerous. It's collaborative project, and if it's not clear for everyone in the consortium what is each other active contribution. I mean, everyone in this consortium, in these projects, can claim ownership. The problem is how you prove it. And as I mentioned before, for instance, patent law, you have some guidance principles how you can claim, or what is actually something that will lead to ownership claim. You can, in the consortium agreement, of course, you can try to elaborate further these principles, but it's really hard because you have several project results, no? Out of every project, you don't have just one thing, you might have several. So basically, the definition of active contribution is very important. What is an active contribution in each project? I think that's something that will help to understand better how can I claim, ownership, and the acknowledgement of these active contributions is very important as well. So there you need. I think that the issue is how do we communicate properly what we're doing, and what are my intentions to collaborate. You have a specific, again, I have to stress this a lot. Go to the consortium agreement, read if there are some specific restrictions regarding the use of the background, for the development of this result or new result. Because perhaps in these terms and conditions for the use of background, you can define or anticipate who will be the owner, or for instance, in terms of databases, again, which is very important nowadays, you might have some terms and conditions that will automatically define who is the owner of whatever comes afterwards. Derivative works. This is something that people should be aware of, and it will simplify the solution to this conflict. Because at the end, everyone wants to claim and say, "Hey, this is also mine." In the worst case scenario, that everybody tries to claim ownership on everything or on something that doesn't belong to them. And I also have seen as another example, partners that went bankrupt. So if somebody was the holder of a patent application, and the company went bankrupt, they have a patent application, it was not granted. When finally the patent is granted, then you have to pay some registration fees. Otherwise, it is not granted. So, and if you're basically establishing, developing a technology based on the patent that was provided by that partner that went bankrupt, you might be in trouble if you don't negotiate better the transferring of this right to saying, okay, fine, I'm just the holder of the patent at the moment, I'm going bankrupt, but somehow there will be a board, a liquidator, someone transferring this right, even though it's just a patent application, to someone else. That someone else should become automatically, let's say, to get engaged with the consortium, because this is also something that should be defined in the consortium agreement. You have all the rules, all the solutions defined in the consortium agreement.
It's also it's complex. It's always complex when it runs into like this, because then it gets extremely legal, right?
Yeah, and you don't know. We never know. I've been in all these projects, and there's always something new, partners leaving the consortium without noticing that they are still liable and legally bound by the obligations in the consortium agreement. So fine, you don't want to work here anymore. You sold your company to someone else. Well, that someone else is still legally bound to this consortium. And if we require the technology that it was originally foreseen as background or result developed by this company, they still need to be available to the consortium. That's it. Otherwise you're exposing yourself to bigger problems. Okay, like someone enforcing this dispute resolution clause.
I guess also this sort of cutting the cake, and because you have talked about clear cases where there's no dispute, it's clear who has what. But this is the case with the hook when you cut the cake over a specific technology, right there.
Yeah.
Naturally, that's a natural conflict point, right?
Yes. Yeah, it is. This is not just to set everything right now in stone, right? I mean, you have the opportunity that normally these projects, they have a duration around 4 years, no? Typically. And in 4 years, you should know who is working in what. You can negotiate, discuss, anticipate. You have enough time, to see how the results are working on, and then anticipate what will be the potential commercialization of the results, and discuss transparently your interest towards post-project use, and define collaboration agreements. This is what the section 9 of the consortium agreement normally said. Access rights for post-project exploitation. The partners can define under fair and reasonable conditions the terms for using that specific result or background that is needed for an exploitation plan. Of course, exploitation plan of another project result. So yeah, you have all the solutions there, but I think it's a matter of for not just the coordinator, but someone else that is engaged in IP management in the project to implement, to run some specific activities with everyone, to define this interest from each one in the project, in a transparent manner to document all the project results, who actually work on what is the status of each technology, also to do some exercises regarding how innovative this result is. You're not going to fight with someone on something that is not commercially attractive.
Nope.
That is not. If it's you got a sample of something that doesn't make anything, and you run some patent prior searches, and then you see that the business opportunities are blocked because you have big players already covering that technology. Perhaps on that particular result, you are not going to be fighting about. But when it comes to something else that is promising, that could be a game changer, then in that particular case, it's better just to identify them in a good way, with the general assembly of the project, talk about it, and see what would be the suitable IP protection strategy and who is going to apply for the patent. If we are joint owners, okay, do you have the money to pay for that patent, or should I just cover myself?
Yeah.
Then let's negotiate how we're going to compensate each other. If there's an opportunity for a joint ownership. If I'm a joint owner, for instance, another question, am I allowed to get in contact or talk to about this jointly own result to your competitor?
Yeah.
You know?
Yeah.
These are things that should be properly managed, addressed by an IP manager. You know, I don't know if it will be the coordinator in this case or something, but
I think what I always look, when I was an NCP and when I've been consulting people on this, both as a civil servant and as a private grants consultant, I've always said, look, because this is the first thing companies say when they, if you want to attract them into an EU-funded project. No, we don't want to share our results. So my reply to that was always, look, there's everything is being defined very clearly. The cake is cut, so everybody will get what everybody can get in a negotiation together with the others. And that's going to be, but you of course have your own responsibility for how to define that, but everything will be talked about and defined in this respect. So, and that's a key point, right? Because it's they can get a lot. This is public money.
Yes.
Yeah. This is taxpayers' money to develop state-of-the-art technology within the area. So that's what they get. That's what you always have to make them realize. You are stepping into a place where you work with the coolest research organizations, the coolest international partners, commercial partners, whatever area you are within, on developing state-of-the-art, groundbreaking technology within your area. It might be your technology that you can move it much further than you would be able to do in a commercial project with one other partner, whatever. So you need to accept that this is taxpayers that is paying for this development of this IP here. And there you have to compromise yourself. It's not the same as if it's doing it yourself. You have to accept that you need to communicate and talk to the rest of your consortium on how do we deal with these results that comes out of this, because it's a joint effort.
Yes.
And there
you have for sure. Yeah, you have. It's a collaborative framework, right? Yeah. Also, big industry, involved in this project. They are sometimes they don't get any funding, right? And still they get a lot of benefit, or they have the potential to gain a lot of not just the knowledge, the expertise. They have also an opportunity to collaborate, with SMEs, with researchers, compensate them accordingly, to their contribution. Maybe even the big companies are involved in in projects only to demonstrate, not to generate the technology. So if I help you to demonstrate something, I didn't develop it. I'm just helping you to show that it can be replicated at this new pilot plant or scale up site. Yeah, to scale it up. Still, there I have a priority when it comes to the negotiation, of the exploitation, right? Maybe the researchers don't have the capacity to turn that formulation. Okay, let's talk about formulation. To turn that specific formulation on a commercial product. I have it if I'm the industry partner. So let's talk business. You don't have the money to cover the patent, but I want you to get a patent so that I can make an agreement with you, or and in that case, I want to make sure that I have at least some sort of exclusivity, a first mover advantage, something like that. It is this consortium, this framework. It is an opportunity for to think about, to look into the big picture, to negotiate, to collaborate, to make something great. You have a big industry, instead of investing a lot of money on their own, they get a support from the European Commission, from taxpayers, in simplifying the way on how the research will be developed, because you have researchers doing the entire framework for them. And also the investment is less, than if they will have to cover the entire cost. They get a support, the researchers, the SMEs, they receive funding. The management of the project is also covered. So it's a good advantage for industry. It's a good proposal. Good strategy for researchers, for SMEs. So I really enjoy working on this project.
I would say the project proposals that I've been working on with big multinationals, right? They set this, they decide. Yeah, I've been writing proposal for Siemens, for instance.
Yes.
For Danish funding, research and development funding scheme. So smaller consortium, but in principle the same setup, where Siemens said, no, we want it like this and this and this. Yeah. Then you have larger projects in Europe I've been dealing with, where I had several, and even competitors I had in one. But then they, they said, we want this and we want this, and they found their way. But if you're big, you normally get a good say because you have a lot of muscle, right? It's unfortunately like this for the SMEs, but the SMEs, they also have their stand on, because they are there because they have a specific technology that these big ones they need and they don't have it.
Yeah, but also there's also we're going back again into the IP management, right? If I'm a small company, and I'm getting in a project with a big company, with a large industry, right? Transnational. And I am the one that is developing that great, valuable piece of technology that I know the large industry will benefit from. Sure, within the project implementation, again, in the consortium agreement, you have some rules. If I'm developing something, the first thing I will do is define very clearly in the consortium agreement what I'm bringing into the project in terms of background. Very well elaborated terms and conditions in terms of post-project use. I will just say everything that is developed from this background, from this technology, all these projects will start from some point. This, in the case of the background, I would say whatever is built out of this for post-project use have to, whatever plan will lead to a negotiation of further agreement, and a further agreement with me on the fair and reasonable conditions, sure. But I want to have this negotiation in during the entire project implementation, no more than 12 months after the end of the project. If you don't talk to me within this period of time, then I'm not going to negotiate anything with you. You can elaborate what type of condition. I'm still remain the owner of this technology, and I have a patent. If it's something that I developed during the project implementation as an SME, I will again try to cover the IP protection of that technology by myself. I will enforce and implement really clear confidentiality rules about my when it comes to the disclosure, the use, the transferring of my result, within the consortium. Sure, I'm talking to a large company about this technology, but that doesn't mean that they will be able to produce something without my permission or replicate this technology without my permission, because I already block it as something confidential, and I can prove that it was only developed by me. Just examples, no? So if you manage as an SME to build a very good IP protection strategy, I think large companies, they also understand that, and they will be willing to negotiate and sit down on a table to negotiate on the access to the intellectual property, right? So that they can replicate or develop their own. And these are, if something is proven, that works for them as well. So I don't see. I know that there's a stigma somehow that large companies will demand everything from the SMEs, from the small fish. Yes, I understand where this is coming from. But
I've seen it. Probably also seen it.
Sure. But and I understand this is great. I mean, for instance, in the grant agreement, there's an obligation to have an agreement, before the project starts. You have to agree on the background. Where do you agree? Where do you define that? Well, you have to have a consortium agreement, and then in that consortium agreement, you elaborate as terms and conditions and so on. Similar, also you have to agree on how do you distribute the budget, so budget and the IP issues as well. It's something that we discussed in the previous episode. So in the case of the when it comes to IP management and during the project implementation, I know that there are a lot of complexities, but we have to look at them as the opportunities to negotiate great agreements, great collaboration agreements, for forever. That's my main message. Maybe I'm dreaming here, but I always do that in my projects, and normally of course there are some cases where people don't want to keep working together, right? It's human nature, or people want to go into explore other technologies and so on. But we had the cases of several consortiums that they always find opportunities to collaborate. After the end of the project, they jump into other projects together, because they believe in these frameworks. That's something that we should aim when we're talking about IP management. Look into the next collaboration, and because that way we all win.
Yeah, you have something on each other, so to say. So if
Exactly.
we just, if we sum up sort of this segment here, so conflict point, so good, successful conflict resolution. Like lots of communication and clear communication. And the horror stories, it's always when things have been not discussed thoroughly, when things have not been properly put down on paper, or when you have something like a bankruptcy, or something like this. That you did not foresee when you did the consortium agreement, or if it's a bankruptcy with an essential technology.
Exactly.
Where, for instance, the background is defined in their legal context as being taken out of not being allowed to use anymore, stuff like this. But again, you cannot. This is life. You cannot safeguard yourself against everything in real life.
Things happen.
Sometimes somebody drive into your car, or you twist your foot. You break a leg, or what.
Yes. Yeah. I think that is the magic of the consortium agreement. How do you elaborate a legal framework? Some rules, some conditions, some terms that will rule the collaboration of all these people working together, without really focusing on the worst case scenario. Describing just one single worst case scenario, but in general, and then you find the solutions within the same document. How can there's a partner that decided to leave. Okay, then you have everything already defined in the consortium agreement. What would you do in that case? Or what happened if the company went bankrupt? What happened if I need something from this other company, the one that went bankrupt? That is already all somehow defined in your consortium agreement, as it is the recommendation from the DESCA model, no? But beyond that, you have to have some additional discussions, I suppose. I mean, most of this conflict, even in the consortium agreement, you have the mandate. It says basically that the partners in dispute, they should aim solving these problems amicably. And what is amicably? And who rules this part of just to make sure that it's solved amicably? Mm-hmm. You could, if I were the coordinator, I will bring these partners together. Worst case scenario, you see that the conflict between two partners will affect the implementation of the project or the impact. Therefore, it's a matter of something to be addressed by the General Assembly. The General Assembly can take decisions that perhaps might not be accepted by one of the party, but if you have the majority, then you see you can move forward. And as in a group, and you cannot prevent that some partner will feel severely affected by something, and then in that worst case scenario, again, you have the dispute resolutions. But I think that if there is an effort, proactive effort on managing expectations and rights and terms and conditions and so on in a very transparent way, looking always at the big picture. What do we want? We want we want products that will go to the market. Mm-hmm. If that's the aim and everyone is on the same page, everyone somehow aligns, Mm-hmm. If it's an innovation action, if we want to see products going to the market, I think it's, sure, you might want to have your publication, for sure, I get it, you want to write your article, but perhaps, you're going to do it, but you can wait a little bit, Mm-hmm. Or you write your publication without this specific information, because then you're going to block me from proving novelty, So this is something that have to be addressed proactively, and it shouldn't be a big problem. To be honest, I can tell you over 25 projects and beyond, I passed already that number. It's something that shouldn't lead to big problems, and everyone should be happy. In Europe, I guess we are very, very lucky to have this sort of collaborative framework sponsored by the European Commission.
Now, what we just did, we went into the next block, which is actually damage control and good practice. But I thought about it when I made the run, so it's going to be difficult. And here I fade out of the first half of this episode. Thanks for listening to this episode of The Grant. All the Grant episodes have their own site on the Grant website. You'll find the link to the episode site where you listen to your podcast. On the site for this episode, you'll find a link to Louis' personal LinkedIn site and a link to RTDS Group's website. Further, there is of course a link to the implementation series where you find the previous 13 episodes in the series. Next week you will get second half of this episode where we look at how to do some damage control with all this. And then there are some lessons learned and recommendations. We look forward to that.